Good afternoon. My name is Oliver Westmoreland. I am IAA registered level 3 immigration advisor, and I am senior immigration advisor with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is exceptions for overstayers. What's an overstayer? Well, in case you don't know, I will tell you. A migrant whose visa has expired already, they're still in the UK, they are an overstayer. Now, this is a very an unfortunate position to be in, because you're really on the wrong side of the law. You're not allowed to work. Not everybody knows that, but it's a true thing. You're not allowed to work. According to the law, you're not allowed to have a bank account. You're not allowed to rent a property. You're not allowed to hold a driving license. This is what the law says. A hostile environment. If you become an overstayer, it's unfortunate. Sometimes you can be rescued from being an overstayer. There are different ways. I'll give you a very good and interesting example. You're an overstayer. You might be able to apply for a family visa as a partner or a parent. On a nice day, it could be successful. The law is it's not completely harsh. Family visa applications, the law is flexible. If you're applying for a study visa, working visa, forget it. You're an overstayer. You're on the wrong side of the rules completely. But this important and interesting exception, applying for a family visa, you might be able to make application. This seminar today is not quite about that. It's about a part of the immigration rules, which is called exceptions for overstayers. Sometimes, in a different sort of way, overstayers can submit an application for leave. This is strongly controlled by the rules. This is a complex subject. I'm going to give you a brief understanding and overview. I'm sure that Mr. Shah will have loads of questions, but this is my brief peroration about this. First of all, you want to extend your visa. You're intending to extend your visa in the UK. You are late for one reason or another. You can submit your visa application up to 14 calendar days late to the Home Office, but you've got to give a really good reason, or your lawyer has got to give a really good reason. This would have to be something strong, like I was in a car crash and I was in a coma, or my house burnt down, or something strong. But if the Home Office think that the reason is strong enough, they will accept the application, your in-country application. They will accept the application. If it's successful, then it's well and good. If it's unsuccessful, you are in big trouble, basically. Interesting legal fact. If an application is accepted by the Home Office, that doesn't cure the overstaying. The overstaying only gets cured if the application is successful. So you make an application as an overstayer, which is why the rule is called what it's called, exceptions for overstayers. That's the first rule, which is on the harsh side, you might say. Second part of this rule is much more complicated, really. You have made an in-time, in-country application, in time, and it's been either refused or rejected. Unsuccessful one way or another. Now, if it's been refused rather than rejected, you're going to have a right to challenge, either by way of administrative review or appeal. If you challenge and it's successful, then well and good. But if it's unsuccessful, you get another bite at the cherry. It's the interesting part here. The rule is very generous, I'd say this. You can have a right to challenge. You challenge. Unsuccessful, either refused or rejected. You have a different 14-day window in which you can submit a completely fresh application. And you don't have to give any special reasons for anything. If it's successful, well and good. If it's unsuccessful, well, you're in big trouble. That's the first. This is a generous rule. Another rule, which is at least as generous, is a bit different. your in-time application has been refused or rejected. If you refuse, you have the right of challenge, as I say. If for whatever reason you don't challenge and you get to the expiry of the right to challenge, the last date of the expiry, but you haven't, for whatever reason, you've got another different 14-day window in which you can submit a fresh application as an overstayer, and you don't have to give any special reasons. That's the basic thing. I just want to clarify something that I said. I said application can be either refused or rejected. Sometimes there's an important difference. Application is refused because there was something wasn't quite right with it. Didn't quite meet all the requirements. Rejected means there was something so bad about the application that the Home Office didn't even consider it at all carefully. For example, you forgot to enclose your passport. You forgot to enclose your TB test certificate. Or even worse, you were of the wrong age for that type of visa. Even worse, you didn't have the right type of leave to apply for that kind of visa. Something seriously bad, the application is not refused but rejected. That is the difference. But these rules are quite flexible, as I say, generous. Even applicants being rejected, you could take advantage of these 14-day rules. Do know, though, I must make this clear to you, if your application is refused, you have a right to challenge, either by way of administrative review or appeal. If it's rejected, no right to challenge. That could be an important difference, but nonetheless, the rule is generous. It came in the last few years as a result of case law. The rule is generous. It can avail those who have been either refused or rejected. Now, Mr. Shaw, I know this is a very complicated subject. I'd like to ask lots of questions.
Honestly, this is a complicated subject, and there are so many people in the UK who either overstay because of no fault of their own, or sometimes they overstay because they just forget to renew their visa on time.
Because they're too busy.
Exactly, and so forth. First, I want to test your memory, and
Oh my God, not that, please.
and I want to ask. You mentioned about this hostile environment policies.
Yes.
Would you please tell the audience who brought these in?
Oh, it was your friend Theresa May, ex-Home Secretary and ex-Prime Minister. I don't know if she coined that term herself personally. Maybe her civil servants were advised. It came under her reign as Home Secretary and Prime Minister. She introduced all these various harsh laws making life difficult for those who were overstayed. Like the things I mentioned, not allowed to hold a bank account. Now, some people might hold a bank account anyway, but it became illegal, apparently. Driving licence. You might hold a driving licence, but it became illegal, apparently. You might be renting a property, but then it became illegal. All these harsh measures, what we call the hostile environment. But I mean, let me contextualise that. Overstaying was always a criminal offence. Knowingly overstaying was always a criminal offence. I mean, not one that usually got prosecuted, but it was a criminal offence. That was already there. She just added lots of other things onto it.
Great, well done. And another dramatic question. Is there any death penalty in the UK for overstaying?
Not as far as I know.
Great, that's a relief. Now, in regards
I think that was a joke, Mr. Shelton.
It was, yes.
You're allowed one joke per session.
Awesome. Now, in going back to the overstaying rules, I understand you mentioned that if someone's on any point-based system categories such as skilled worker visa, student visa, it can be fatal to the new application. If someone finds themselves in an overstaying situation, is it best for them to leave the UK and make a fresh application to come back?
Look, if you or your clever lawyer or advisor could take advantage of paragraph 39E, which is the part of this the rules, exception for overstayers, if you could avail yourself of that, you might get out of the problem. The only problem that remains is that you will have a period of overstaying on your record, because let's say you can submit an application, let's say you're late, you can submit an application, you submit it as an overstayer. It doesn't, as I said, it doesn't cure the overstaying. That period of overstaying stays on your record. Similarly, let's say it's a working visa, study visa, have administrative review unsuccessful, you can make fresh application. But you make the fresh application as an overstayer. So, and that stays on your record even if it's ultimately successful. So you will have that period of overstaying on your record, but may not be too much of a problem. Let me clarify that just a little bit more. You have the right to administrative review or appeal. I said if it's unsuccessful, you can make a fresh application. But actually, it's a bit more than that. If you withdraw the challenge, again, you get a 14-day window for a fresh application. If you can take advantage of those rules, you might as well stay. Because, I mean, you're going to have a period of overstaying in your leave, and it could cause a problem. But if you go back home, you've got another period which it doesn't count, haven't you? So there may not be any advantage. If you can succeed on these rules, it's best to try. But of course, if you make the fresh application and it's unsuccessful, then probably you might have to end up going home.
Okay, thank you for elaborating on that. I want to link the overstaying and see how it may impact someone applying for indefinite leave to remain on a long residence route. Is it possible for someone to have an overstaying history? Could be a short overstay, let's say 10 days or so, and they could still be successful in making a long residence ILR application.
You mean like a 10-year long residence application?
Exactly.
Well, look, I'm not going to give the complete answer. There's complicated case law about this. They might actually be able to succeed in the application, but some periods of their history will not be taken into account. If you want advice on that, you should consult a good lawyer like Mr. Shah. You could possibly succeed, but the rules are complicated.
Great. Thank you so much for answering that question as well. Well, it was a pleasure seeing you in this vlog, and we see you in the next one.
It was a pleasure as well. Thank you so much. See you soon.